Good day, everyone. So, we are now on the topic law on corporation, specifically incorporation process. Okay, so let's begin with the creation of a corporation. In creation of a corporation, we are having a promotion. So, this promotion includes activities done by a promoter for founding and organizing the business or enterprise of the issuer. So the concept of promoter, actually a promoter could be a natural person or juridical person, which bring persons interested to invest. Okay, so again, this is usually a natural or juridical that discovers a prospective business and brings persons interested to invest in it through the formation of the corporation. So although the law does not require the services of a promoter as a precondition to incorporation, but a promoter facilitates the creation of the corporation by negotiating the contracts for its initial operations, including the subscriptions to its capital stock, incorporating the business, and helping the management start its operation. So that's the nature of the promotion or the promoter. So that's the job. Now, what is the liability of the promoters? Okay, so a promoter is personally liable for contracts made for the benefit of those proposed corporations. Okay, so if the incorporation of the corporation does not materialize, so the promoter remains personally liable. So if the corporation is formed, he remains liable until the corporation ratifies or adopts such contracts or releases him from the liability. So the third person must also agree to absolve him from the liability. So that's the nature of the promoter. Siya yung tagadala ng mga persons who are going to invest. He also manages, okay, the incorporation process of the corporation, and he will be liable, okay, personally liable sa lahat ng actions niya or consequences niya uh, in the scope of his obligation. Okay, so he or she will be liable or personally liable if the incorporation did not materialize. But he will be released from the liability if ever it is approved by the corporators or the founders of the corporation. Okay, so he will be released from the liabilities. Okay, so that's the concept of promotion. Let us now move on to the steps of incorporation. Now, the first step of incorporation is we have to verify muna, okay, with the SEC, the name to be used before drafting the execution of AOI. Okay, so we have to verify the name to the SEC. Okay, when we are formulating the name kasi ng corporation, no corporation name shall be allowed if the proposed name is identical or deceptively or confusingly similar to that of any existing corporation or to any other name protected by law. Okay, so if the name is also patently deceptive, confusing, or contrary to existing laws, so hindi po pwedeng ma-incorporate yung corporation. So you have to change the name if it is confusingly similar. If it is approved by the SEC or the Securities and Exchange Commission, then we can now proceed to the drafting and execution of articles of incorporation by the incorporators and other documents required for the registration. So in here, the treasurer in trust of the proposed corporation must also execute an affidavit to the effect. So when they draft the execution of AOI, okay, so we have a requirement here which is required from the SEC, okay, that they must execute an affidavit. Okay, anong affidavit ba? That at least 25 of the authorized capital stock has been subscribed and at least 25% of those subscription has been paid in money and or property. So if the payment is in money, that the payment is on deposit with the bank designated by the corporation. So, kailangan may certificate of deposit po tayo. If ever, okay, money po yung um, money po yung nature ng subscription natin. Okay, so after that, we are now going to file with the Securities and Exchange Commission. the articles of incorporation together with, in case of a corporation governed with a special law, for example, educational institution, a favorable recommendation of the appropriate government agency, example, DepEd, so kailangan pa siyang may recommendation if it is governed by a special law. Okay? Ayan. So after which, there when you file the articles of incorporation to the SEC, okay, ang nang mangyayari dyan is there is a verification certificate authorizing the use by the proposed corporation of the name stated therein. Yan po yung ipapasa mong document, verification, na na-verify na ng SEC. We have treasurer's affidavit, yung 25% of which is subscribed, and 25 is paid. Okay, after that, the certificate of deposit, and then another document that you or the corporation undertake to change the name if it is similar, and other documents that may require, such as endorsement of the government agencies. Okay, then after that, are going to pay na in filing for publication and other fees. So, after payment of the filing and publication fees, there is now an issuance by the SEC of the Certificate of Incorporation. So, the issuance of the Certificate of Incorporation is the operative act that will grant juridical personality to the corporation. So, the moment na binigyan kayo ng license to operate, then legal na po ang corporation ninyo. So, a corporation commences to have such personality on the date stated in the certificate, which is the date of issue. So, ano ba yung license to operate na binibigay ng SEC? Actually, it has two nature. Okay, it has two franchise. We have primary franchise and the secondary franchise. The primary franchise, this is also known as corporate franchise. It is refers to the right and privilege granted by the state to exist as a corporation. So the primary franchise is vested in individuals who compose the corporation and not on the corporation itself. While the secondary franchise, this refers to the different rights, privileges, and powers which are obtained by a corporation, which are not a prerequisite to corporate existence, such as right to occupy and use public places for the operation of a system of water, gas works, electricity, lighting plants, and railroads, and etc., or to operate a messenger and express delivery service. So, yung primary franchise natin is a franchise that you are given by the SEC to operate, while the secondary franchise talks about the different rights and privileges and powers as a corporation. Okay? After given the franchise of the Securities of Exchange Commission, there is a formal organization and commencement of the transaction and business followed. So if these are conditions subsequent which may be satisfied after the substantial compliance in order that a corporation may legally continue as such. So the formal organization would involve adaptation of bylaws and filing in the name of the SEC. Okay, so when we say bylaws, these are rules of actions adopted by a corporation for its own government, for the government of its stockholders or members, and those having the direction, management, and control of its affairs. So therefore, ang bylaws, these are the rules and regulation inside the organization. So, ayan. Then, after also, there is an election of board of directors, okay, as to stock corporation, or trustees as to non-stock corporation, and officers. Then, there will be a plan for the establishment of principal office and providing for subscription and payment of capital tax. Okay, so we are in the Articles of Incorporation. When we say Articles of Incorporation, it is the basic document or contract in corporate law defining the charter of your corporation. So we have threefold nature in this. So it is a contract between the state, okay, or the government and the corporation itself. It is also a contract between the corporation and as to the stockholders, and a contract between the stockholders. So what's the significance of articles of incorporation? So The significance of this is the issuance of the certificate of incorporation signals the birth of the corporation's juridical personality, and it is an essential requirement for the existence of a corporation, even a de facto one. So, last discussion, we already know paano magiging de facto yung corporation. Okay? So, it could be because of the name. It's because of the number of residents or composition of the requirements ng residents as to foreigners is not satisfied kaya ka naging de facto even you validly applied it in good faith. So, ganun siya. Okay? So, the importance of this is after the issuance of the AOI and if it is approved by the SEC, it will commence. Okay? The corporation will commence its operation and legal na po siya. Now, we have the contents of the Articles of Incorporation. So, ang content lang naman ng Articles of Incorporation are the following. Siyempre, the name, the specific purposes of your corporation, and when the corporation has more than one stated purpose, okay, it shall indicate the primary and the secondary purposes. Next is the place and the principal office. Saan ba nakalocate yung company ninyo? The term of which the corporation is to exist if the corporation has not elected perpetual existence. Kasi nga may life yung corporation, right? 50 years. So, it is also included here the names and nationalities of the residences or address of the incorporators. So, kailangan natin yan. Okay? The incorporators are the founders of the corporation. Next is the number of directors. How many directors we have in a corporation, and it shall not be more than 15, or the number of trustees which may be more than 15. Okay, so the names, nationalities, and residences or address of person who shall act as directors or trustees until the first regular directors or trustees are duly elected and qualified in accordance with this code. If it is a stock corporation that you are forming, it is also needed the amount of the authorized capital stock to be stated in the AOI. How many shares? Okay, the par value of each, and then the names, nationalities, and residents ng mga subscribers natin. Okay, and the statement that some or all of the shares are without par value if it is applicable. If it is non-stock, okay, the amount of the capital, the names, nationalities, and residence address of the contributors, and the amount contributed by each. Okay, and such other matters consistent with the law which the incorporators may deem necessary and convenient. Okay, so we have now the components of a corporation. So we have corporators whose compose the corporation whether stockholders or shareholders. We have also incorporators. These are the stockholders mentioned in the NDAOI. So these are the founders. Okay, so having signed the AOI and acknowledged the same before the notary public. So the number and qualification of incorporators. Okay, any person, partnership, or association or corporation, singly or jointly with others but not more than 15. So, klaro tayo dyan. Okay, hanggang 15 lang. If the natural persons who are licensed to practice a profession and a partnership or association organized for the purpose of practicing a profession shall not be allowed to organize as a corporation unless provided in the special laws. Okay, so we have also incorporators who are natural person must be of legal age. So, hindi po pwede maging incorporator ka kapag hindi ka legal age, lalong-lalo na hindi ka pwede maging stockholder if you are not on the right age or age of legality. Next is each incorporator of a stock corporation must be a subscriber of at least one share. And a corporation with a single stockholder is considered as one-person corporation as described in the title, Section 8, Chapter 3 of the Corporation Code. So, okay, so meron po tayong one-person corporation which is now a new pronouncement of or changes in the corporation law. Okay? To continue, so we have stockholders. So these are the owners of shares of stock in a corporation. Okay, they are holders of a share of a corporation with interest over the management control, income, or dividends and assets upon liquidation of the corporation, so simply they are the investors, okay, who subscribe shares or capitals of stock in a certain corporation. And members, they are corporators in a non-stock corporation. Magkaiba kasi yung term. Kapag stock corporation, ang tawag sa atin is stockholders, okay? But in non-stock members po. Okay? So, sa stock corporation, if ang tawag sa board of director, if ang tawag natin sa mga higher position is board of directors, sa non-stock is trustees. Okay, so we have other components here, the promoters, we already discussed this. The one who promotes the corporation, okay, the one who manage at the beginning, who find um, investors to invest in a corporation. We have also subscribers, the persons who agreed to take and pay for original and issued shares. Okay, formed or to be formed. A subscriber may not be a stockholder, but he becomes a stockholder only from the time his subscription is accepted by the corporation or the corporation's offer is accepted by him. So, if you're a subscriber of capital stock, okay, you will never be called stockholder unless na lang if it is accepted, or in other words, if that subscribed capital stock is fully paid. Kasi when we are going to fully pay the subscribed capital stock, we are going to issue, the corporation will issue a certificate of stock. Then therefore, if we have the certificate of stock, then then we will be called subscribers or stockholders. Okay, and we have also underwriters, the persons who guarantee on a firm commitment and or declare the best effort basis the distribution and sale of securities of any kind by another company. Let us now move on to the capital stock requirement. So during the uh, steps in the incorporation, I already shared this one a while ago, okay, but we have to repeat it. So the capital stock requirement of a certain corporation is there is a minimum subscription and minimum paid up capital no longer required except as otherwise provided by special law. So that as per revised corporation code, remove the requirement 25% subscription and paid up capitalization except as specially provided in special law. So ni-revise siya, ni-remove yung requirement na 25%. So, after incorporation, in case of increase, at least 25% of the increased capital stock must be subscribed and at least 25% of the amount subscribed should be paid in cash or property, the valuation of which is equivalent to at least 25% subscription. So, therefore, it was revised, hindi na kailangan na during the incorporation, dapat may 25-25% rule na tayo, that 25% must be subscribed and out from the 25%, 25% is paid. So, ayun, iniba na siya. So, after incorporation, okay, you must comply that 25-25% rule. Then, the issuance of shares from the unsubscribed portion of authorized capital stock not subject to any 25% payment requirement but based on the terms and conditions which the board may determine.